Major funding for the Layman's Lawyer is provided by the Georgia Civil Justice Foundation. Visit the foundation at www.civiljustice.org.
I'm Dennis O'Hare. Welcome back to the Layman's Lawyer. You try to hang on to your stuff while you're around, and most of us would probably like to see it go to the right people after we've passed on. Now, we have probably made our relatives mad at us at least a time or two while we're here. You certainly don't want them mad at you after you're dead. So tonight on the Layman's Lawyer, we're going to take a look at planning ahead, wills, estate planning, and trusts. And with us for this edition of the Layman's Lawyer, Adam Gaslowitz of Adam Gaslowitz & Associates. He helps people after they've gotten into trouble. And William McCrae of Chamberlain, Herdlicka, White, Williams, and Martin. He does estate planning. He tries to help people avoid having to see Adam Gaslowitz later on. Good to see you. Welcome to both of you.
It's good
nice
to be
being
here
with us on the Layman's Lawyer. Mr. Gaslowitz, President Bush was in Atlanta back in February, and during his speech he talked about ending the estate tax permanently, and that got one of the biggest ovations of the entire speech, even bigger than going after Saddam Hussein. Nobody likes the death tax, do they?
Nobody likes being taxed on passing their property to their children, but I don't think most people understand that the death tax doesn't really affect most people.
Yeah, well, a lot of us worry about it. Do we have to?
I don't think most people have to. The exemptions on how much you can pass to your family is $1 million per person, $2 million per couple. So unless your estate is over $2 million, there's really nothing for you to worry about. And there are a lot of planning techniques that would take that above that. So for the most part, it doesn't affect most people in America.
Okay, and the limits are going up in the next few years also, aren't they?
The limits are going up. They just went up to $1 million. They will go up to $1.5 million per person, I think, in 2004.
Now, there is one thing that'll be coming up later on, around 2010, I believe. There's a sunset provision on all of this where it's possible the estate tax could come back and back at some at much lower levels later on, but going backwards, I think, would be political suicide. Is it likely that we'll see the return to the estate tax the way it used to be, where it would affect a lot of people?
I don't think so. Right now, the plan is for it to be completely eliminated in 2010 and then to come back in 2011.
Yeah.
So do we really have a repeal?
Yeah.
We have a temporary repeal,
okay,
and then it comes back. I don't think it'll ever come back the way it used to be. And there's a lot of people who question whether it will actually be completely eliminated or whether we'll simply increase the exemptions to the point where it doesn't really affect many people in America.
Yeah, I guess, but there's always this saying that, you know, well, we've got Social Security to shore up, we've got Medicare to try to shore up.
Right.
The government's going to need money. We may see an estate tax in some form, probably, right, Mr.
With the budget deficits, it calls into question whether we can ever really have a complete repeal.
Okay.
Right now, from our side, we say probably not.
Mm-hmm. But the average person now probably is not even going to have to worry about it.
The average person with the least little bit of good planning can avoid the estate tax altogether.
Okay.
For all practical purposes.
We're not even talking about the average person. I mean, 99% of Americans won't be affected by the estate tax, even as it exists today.
One other thing about estate taxes, Mr. McCrae, if you and your spouse co-own everything, or almost everything, and one of you passes on, you're not going to have to worry about that either, right?
Well, we need to be a little careful there, because co-ownership of property may cause problems rather than alleviate problems. With a properly drafted will or trust, we can, and with proper ownership of property, titling of property, we can avoid the problems.
Okay.
But co-ownership can be both a benefit and also a problem.
Okay, we'll pick up on that in a moment, but let's get to some of the basics here. Why do you need a will in the first place, Mr. Gaslowitz?
Most people need a will initially just so they can name a guardian for their children. The only legal way to do that in Georgia is through a will. If you want property to go to certain people, certain specific items of property to go one place or another, you need a will to do that, or a trust. Mm-hmm. To name people who are going to take care of your estate, whether it's someone to name as an executor or a trustee for minors, usually you do that in a will.
Okay. What happens if you die without one?
If you die without one, the state has a will for you. And
it's awfully nice of them.
It is nice of them. They essentially specify who gets your property, and that it's sort of a graduated list. If you die and you have a spouse and children, your estate gets split among your spouse and children. If you don't, then it gets further removed from that, and it goes to your siblings and to your parents and then to cousins and so on and so forth. So the state will specify who gets your property.
Okay, Mr. McCrae, I guess then the reason, and it's kind of a reverse of what we just said, but the fear of dying without a will is that the state might have a say in where your property goes if you don't want it just to go automatically to your next of kin, or especially that the state will have a say in where your children go.
I think most people look at their finances. They worry about accumulating for the benefit of their loved ones. They plan for the future. Having a will is a continuation of that planning. I think that if people gave 2 minutes of thought to the notion of passing away and losing all control of their wealth, when they've been spending a lifetime working to provide for their loved ones and accumulate for their loved ones, they'd think twice. So it's just good planning.
Mr. Gaslowitz, can you write a will anytime, anyway? I mean, if you wrote on a scrap of paper, I'm leaving everything to my chihuahua, I mean, is that a will?
Not in Georgia.
In some places it is.
In some places it is. Those are called holographic wills, and they're not legal in Georgia. But you can do a will almost any time, anywhere, as long as you had it properly witnessed.
Okay. Do you have to have a lawyer, Mr. McCrae?
You do not have to have a lawyer. As with many things in life, you would be remiss or taking your life in your own hands to do planning without the benefit of professional counsel.
Now, I'm going to tee one up
let the
for
buyer
you.
beware.
I'm going to tee one up for you because you're both lawyers, but what about the will kits that say, you know, hey, lawyers have drafted this, you don't need to pay the lawyer, we got it all set for you, you can do it.
I suspect that Adam sees problems in his litigation practice by virtue of people who have gone that route.
Yeah, you can create a valid will with a will kit. I mean, there's nothing illegal about the document that they create. The problem with most will kits is there's no planning that goes into it. So what you don't get is the planning part of estate planning. All the little things that might come up, all the things that most people hadn't considered, you don't have when you're simply checking off boxes on a program.
Okay. Mr. McCrae, can you change your will at any time, though?
You can through a properly prepared and executed and witnessed codicil. Yes.
So you don't have to go rewrite the whole thing. You can say, all right, I want to change this section, and that's called a codicil when you do that?
That's correct.
Okay. But you have to have your signature and a witness, and they all have to be valid and so forth.
Proper formalities should be observed.
Okay.
Right.
Suppose you get married and you weren't married before. Suppose you get unmarried and you were married before. Mr. Gaslowitz, does that invalidate your will?
Getting married without the will specifying that it was done in contemplation of marriage would invalidate the will. Getting divorced in Georgia used to invalidate the will. Now it simply treats the spouse as having predeceased you. So it doesn't completely invalidate the will, except for the part of the will that dealt with that spouse.
Are there any other life events that can invalidate your will?
That can invalidate your will?
Yeah, that can say, okay, we got to write a new will.
Well, if you have a child that you didn't contemplate. Most wills are drafted in contemplation of the birth of future children, but not every will is. And if you have a child that isn't named in the will or wasn't contemplated, it would at least be invalid as to that child.
Okay.
Essentially, that you'd have that child be treated as an intestate heir.
All right.
Dennis, I think that the more important question that your viewers are going to want to think about is, are you messing up your planning or your lack of planning by getting married or by getting divorced?
Or by having children.
Or by having children.
If you don't have children, you won't have problems.
Yeah.
And as with one's financial planning, extreme care should be taken to just review, update, and make sure that you have your affairs in proper order when you have any major life event like that.
And one of the things, Mr. McCrae, you have to do when you put together a will is name your executor. What does an executor do, first of all?
Well, the executor is essentially your personal representative. They are charged with taking the will, tendering it to a probate court, and then going through the administrative process of following the directions that are in that will to make sure that property is properly handled.
Okay, and presumably then this is someone who would, as you often hear the phrase, know what you would have wanted done, right?
Oh, that's a big assumption being made. One should take real care to select carefully an executor or a trustee of any trust because they are charged with following those instructions. And if your instructions are not very detailed, you better hope that they know you well. Of course, that's another reason for good and careful planning.
What kinds of problems do you see with executors who weren't really the right people for the job?
Probably a third of the litigation we get involved in has to do with the poor choice of either an executor or a trustee. A lot of times it's simply a knee-jerk reaction. The lawyer will ask the client, who do you want to be your executor? And they will say, well, I want my spouse to do it, and then I want my oldest child next, and my next oldest child after that, without any thought given to, do these people know how to manage finances? Do they understand what it takes to administer an estate for what may be a year or more? Do they understand the family dynamics involved in dealing with the different children or different emotions that run between family members? Are they capable, if they're a trustee, of managing assets for what may be years or decades? There's a lot that goes into that, and to just simply automatically name your children as opposed to some financial institution.
Yeah, in a lot of cases you might be better off naming a bank or someone at the bank as your executor, right?
A lot of times you are, and that often avoids a lot of the problems that you have with individuals who don't know how to account for the assets they're managing, don't know how to manage the assets they're dealing with.
Okay. Mr. McCrae, what should the will cover? I mean, pretty obvious you might say, oh, okay, I know what, you know, I'll put in, okay, the house goes to so-and-so or whatever, the big stuff.
Sure.
But how technical, how detailed should you get in that will, and what should be in there?
Well, it depends. Folks who have a great deal of wealth obviously have a number of tax issues that they'll want to address. Folks who have mixed or blended marriages, second marriages, minor children, all types of different issues can be covered within the context of the will document.
So the will can include anything you want, right?
Basically.
Yeah.
No lifetime planning is done inside of a will. That, in fact, is a time at which one might consider preparing a trust of some sort. But to account for those things that take place after your death, that's where the will is most valuable.
Distribution of your assets.
That's
basically.
correct.
Okay. And that brings up the question of trust, and Mr. McCrae, I'll stick with you for a second. What is a trust as opposed to a will? They work together, really, don't they? The trust can be part of the will, is that right?
Trusts are a big part of our planning practice, and they can accomplish any number of objectives, from income tax planning, estate tax planning, effective control over assets.
What are some of the most common ones?
Item number one would be a revocable living trust. People have heard about those. Those are often looked at as a will substitute. That is a means by which assets can be transferred into the title or into trust or in the name of a trustee, and that person is charged specially with following your detailed written instructions about the management and disposition of property.
Okay, so for instance, let's say, and this is while you're alive, right?
Yes,
yeah.
You would execute one while you're still alive.
Yeah, I mean, I'm sorry, would it cover the disposition of assets while you're alive? Let's say you wanted to make sure that you gave things to children while you were still alive that maybe you weren't capable of saying anymore. You know, well, this should go here and that should go there.
Actually, a revocable living trust is often used for your own incapacity planning.
Yeah.
One situation that people will often face when they become elderly is that they have some sort of debilitating event occur and they lose all control over their assets. With a properly crafted trust, one can entrust the management of your affairs to someone else to deal with those assets while you're still alive, but in accordance with your detailed instructions.
And those are very good things to set up, especially if you think, well, you know, I'm healthy now, and I'm
right.
Maybe even if you're young, you say, you presume you're always going to be healthy. But let's say you're in an accident, and you're incapacitated for a long period of time, possibly for the rest of your life, and can't make those decisions.
Absolutely.
It's a good thing to set up.
Absolutely.
Okay. Mr. Gaslowitz, what about a trust that works more after you've passed on?
The two most common trusts are trust for minor children and trust for spouses.
And what do those do? They basically dole out the money over a period of time? Is that what they do?
Most minors trusts assume that both parents have died. They will dole out money for the child's life, well, not for a lifetime, but as long as they're a minor. Make sure that their education and health and maintenance is taken care of. And then at some point, after they are no longer a minor, it will pay out the principal. A lot of times, and something most people need to think about is when do you want your child to get that money? A lot of times, people may not be worth a lot of money while they're alive, but at their death, there's a lot of life insurance that kicks in and a lot of other assets that get sold. So these trusts can be worth sometimes millions of dollars. You don't necessarily want your child to get it when they turn 18, so you want to think about maybe paying it out starting at age 25, or maybe paying it out in chunks, maybe at 25 and 30 or 35, so that a child maybe gets a chance to manage a chunk of money, possibly squander it, and at least not have wasted their entire inheritance. There's still more money coming down the road. But the trust would manage it during that period.
In addition to children, what's another reason to set up a trust? Are there some other fairly common ones?
Marital trusts, there are different types of marital trusts. Some are set up for tax purposes. Some are set up just to protect the surviving spouse and children from a separate marriage. Real common problem is if you're in a second marriage situation and you have children from a previous marriage, most people still want to leave their estates to their spouse. I mean, that's who they want to take care of. Usually the children are grown at that point and you're not worried about supporting them. But at the death of the second spouse, you want to control where those assets go. If you leave your assets outright to your spouse, oftentimes it will go to his or her surviving children. Whereas if you leave your assets to your spouse in trust, then you can specify in your will where those assets go at your death.
And it can get real tricky when you have yours, mine, and ours.
It's very complicated.
Let's say you had children from a previous marriage, your spouse had children from a previous marriage, then you have some of your, by both of you. You really do need to work up a trust so that everything is settled about where your own personal assets go.
Sure, and it's one of the easiest things to at least anticipate in terms of what may create a dispute down the road is if you've got children from blended marriages, you know there are going to be problems. You know, stepchildren and step-parents are notorious in terms of their relationships.
You see a lot of them, don't you?
We see a lot of them. but these things sometimes are so simple to resolve simply by taking into consideration what you want to happen to your estate and what you want to happen after the surviving spouse goes.
And so then that's where the trustee comes in. You have to, as we were saying before, you have to be very careful who you name as executor. You have to be very careful who you name as the trustee. And they don't have to be the same person, do they?
They don't have to be the same person. And they don't have to be just one person. Although I can tell you that, you know, naming your surviving spouse and one of your children from another marriage as co-trustees generally doesn't work. That tends to create...
Not a good idea.
No, but you'd be surprised how often people do that. They think they're going to create some sort of check and balance on the system, and instead it just creates conflict.
All right, Mr. McRae, let's come back for a moment. We were talking about how detailed you should get. What we've been talking about is big stuff. You need to get really detailed about where the money will go as far as your children are concerned once you die.
Right.
But what about the little stuff? You know, that ugly doorstop that everybody just seems to have a real affection for, or, you know, the pet chihuahua or whoever it is. I mean, that sounds like small stuff, but a lot of people fight over that, don't they?
Oftentimes, communication within a family is far more important than having your lawyer. Simply discussing your desires and those of your loved ones together in times when you're not in a rush to complete planning is very important. And we encourage not only that people come see us and do good planning that they may not be able to anticipate, but also that they communicate.
But should you put all the little stuff in the will? I mean, you know, I will that Slim Whitman CD. To, you know.
Well, gee, the Slim Whitman CD,
Yeah.
that's important.
That is. But I mean, do you have to get that picky?
You don't have to, but folks often like to, and that's fine. That can be incorporated right into the will. It can be incorporated into a memorandum that's referenced by a will. Obviously, detail helps.
Yeah, Mr. Gaslowitz, people do fight over the little stuff, don't they? I mean, you see people spending more money fighting each other than the thing is worth.
Sure, it's not uncommon. For some reason, personal property seems to create more emotional issues than anything else. There's a lot of sentimental value tied to engagement rings and mantle clocks and wedding gowns and things. It's important to put in your will the things that you know are going to somebody in particular, or the things that you know are going to cause problems. And it's also important, to the extent you don't, to put a mechanism in your will for how you're going to divide things up. You know, a lot of times your personal property will get divided up by your executor, however the executor chooses. But if you say, you know, my kids are going to get a chance to pick, you know, they're going to alternate picking who gets what, or create some other mechanism that tends to help a little bit.
Okay.
You can also give things away while you're alive.
Yeah.
You don't need to wait until you've died.
And doesn't it also help to sit down with them? I mean, even though your word might not be good enough once you're gone, at least if you're sitting down with everybody and you say, look, I want, this is going to so-and-so and that's going to so-and-so, at least you can prevent some trouble.
Yes, communication helps a lot. I don't find people communicate that well in general with their children. When it comes to their estates, people tend to be somewhat secretive about it.
Yeah.
But yes, that would help a lot.
Yeah, it certainly is a lot better than trying to hold a seance and ask you after you're gone. Can you,
if
yeah.
I may, before we get off that topic, when folks come in to visit with us to do good estate planning, one of the things that is part of that estate planning that we're not really going to spend time on today is critical health care documents.
Yes.
And in terms of communication with family and with loved ones, not only is it important to execute those documents and think about them, but it is absolutely key that you make sure that your loved ones know where those critical health care documents are.
The powers of attorney, for instance. Yeah.
But also to let them know what your wishes are about those important items.
In other words,
that avoids conflict.
If you're on life support, but there's no likelihood that you will ever be
Right.
able to be revived, for instance.
That's
those
correct.
kinds of things. Very important things to do, and they're not, it's not like disposing of your assets, which is what we're talking about, but those are part of estate planning too, aren't they?
They are indeed.
And most attorneys will do those in conjunction with wills.
Yeah, any good attorney is going to ask you about that,
Sure.
right? Okay. Can you disinherit anybody? I mean, you don't like your oldest child, for instance. Can you, a relative as close as that, you can still legally disinherit them, can't you?
In Georgia, you can disinherit anybody. You can disinherit your spouse in Georgia. It's the only state, I
Wow.
believe, in the United States that you can do that, but yes. You can give your property to whoever you want as long as you're competent to do so.
Okay. But can that happen by accident? Do we run into people who find themselves disinherited when they did,
Sure.
they knew they weren't supposed to be?
Sure, one of the things you need to watch out for is how are your assets titled. If your assets are titled in joint names with somebody, then those assets pass outside of your will, outside of your probate
A joint
estate.
bank account, for instance, that says with right of survivorship.
Sure, it passes by operation of law to the surviving account holder, the
Yeah.
same way a POD would, a pay-on-death account would.
Okay. An insurance policy is another one, right?
It
Mr. McRae?
certainly is.
Where
That
you
is
name a beneficiary.
check the box and name your beneficiary. You raise an extremely important point about people's planning. Folks can come and do good will planning or good trust planning, but if appropriate care is not taken to examine how assets are titled, all of the good benefits of that estate planning may be inadvertently circumvented.
An example, you have an insurance policy on your life. Let's say you were married once before. That
Right.
your spouse then was named as beneficiary. You're now married again, but you haven't checked to change the beneficiary on that insurance policy. That could cause big trouble.
Yes, the contract still stands, and the insurance company will pay the person that they are obligated to pay.
Who will probably be very happy to get it.
Ex-wives are always happy with surprises like that.
Which reminds me, we've got only about a minute or two here, but Mr. Gaslowitz, if somebody doesn't like what's happened, contesting the will, I mean, Anna Nicole Smith was a poster child for all of this.
Yes.
But is it hard to contest a will in Georgia?
No, it's actually very easy to contest a will. All you have to do is, when the will is offered for probate by whoever is doing that, usually the named executor, anybody who's an interested party, spouse, children, just files what's called a caveat with the probate court.
What do you have to prove, though?
You've got to prove, there's a list of things.
But what are the most common ones?
The most common ones are that the testator was incompetent at the time they did the will, or that the testator was subject to undue influence. Essentially, somebody else substituted their judgment for the judgment of the testator and got them to do a will.
So the person contesting your will has to prove generally that either you didn't know what you're doing or someone else made you do it.
Yes.
Is that hard to do?
It's pretty hard to do. Statistically, those contests don't succeed that often. Unfortunately, they're brought pretty often, and they tend to cause just as much trouble whether or not they succeed, because it tends to drag out the probate process for sometimes years. It tends to tear families apart. They're very emotional issues, and the fighting can go on for quite some time.
About 30 seconds left here, Mr. McRae. Let's run over a quick checklist then of things you ought to do to avoid trouble in advance here.
Communicate with your family. Get with professional counsel, your CPA, your financial advisor, your insurance professional, and a good planning attorney. And carefully think out, as you do with your financial planning, the things that you want to do, the controls that you'd like to place on wealth, and the way that you would like to have wealth transferred. That's most important.
Right.
And same thing with the critical health care documents. Communicate.
Great. Thanks to both of you for being with us on
Thank
this
you.
edition of The Layman's Lawyer.
Thank you.
Thanks to all of you. Do that little planning. You'll save yourself and your loved ones a whole lot of trouble. We'll see you next week on The Layman's Lawyer.
Major funding for The Layman's Lawyer is provided by the Georgia Civil Justice Foundation. Visit the foundation at www.civiljustice.org.